Bom dia, senhoras e senhores. Eu vou começar a agradecer a organização da conferência.
Particular to Medel and Professor Paulo Pinto Albuquerque for the kind invitation to speak today, and let me greet the remaining members of my panel. I think that a lot of things have been said so far on the rule of law crisis in Europe, and I will try not to repeat a lot of the ideas that were expressed here yesterday and today, but at a certain point I'm sure that will be somehow inevitable. The idea of my presentation, which is a very brief presentation, is just to give an additional contribute to the debate, and I will be as short as possible and try to avoid unnecessary repetitions. And for that purpose, I will make a presentation in 4 basic points, very short ones. I will start with a few words on the nature of the rule of law crisis. I will then refer to the Polish case and the Hungarian case, particularly in light of the Court of Justice jurisprudence, and I will give some hints and some clues with regard to the future action of the European institutions, which are somehow in line with what the previous members of the panel have already put forward. So, to start with the beginning, let me say that I think that the crisis we are facing today in Europe is probably the most complex crisis that the European Union has faced since the very beginning. This is truly an existential crisis in the sense that it goes to the heart of the European project. It shakes the foundations of the European Union. It compromises the common values in which the communities were initially built. As every EU law student learns in school, and particularly in the universities, the European communities were built as an instrument to promote the rule of law and democracy in Europe, and it's precisely the threat to this original vocation that is at stake at the moment. Secondly, it's also a crisis that, although it discloses the imperfections and the shortcomings of the European model, particularly of the arsenal of juridical and political guarantees that are available in the European Union to ensure the respect for the rule of law, it makes us question the very fundamentals of the European model, in particular the nature and scope of EU federalism, the balance between member states' competencies and those of the European Union, the reach of fundamental rights protection in the Union, and the supremacy of EU law as understood by the Court of Justice. Thus, considering not only the centrality of what is at stake, which to me is the survival of liberal democracy as the system of government common to all member states and underlying to the Union itself, but also considering the challenges and questions that the crisis brings along, I think this is probably the most complex and important crisis that the Union has faced since its inception. Not everything is bad or damaging in this crisis. As it has been said yesterday, this is also a unique opportunity for the Union and the Member States to openly reaffirm and reassert their common values and the essence of European foundations. It has equally proven to be a moment to further develop and improve the so-called rule of law toolbox or rule of law kit that has been created under the current version of the treaties. And last but not least, it has provided the European institutions a renewed opportunity to promote integration through law. And this is particularly visible in the jurisprudence of the Court of Justice. The decision that has been widely referred to since yesterday in this conference, in Associação Sindical dos Juízes Portugueses, and also the decision of the Court of Justice to apply a penalty payment to Poland in the amount of 1 million euros per day within an interim measures procedures, shows how far the Court of Justice is actually willing to go to ensure the respect for the rule of law. The most visible face of the crisis is undoubtedly, I would say, the Polish situation or the Polish case. It has been widely referred to. Poland is under Article 7 since 2017, and the conflict has escalated recently with the delivery of the decision by the so-called Constitutional Tribunal of the Republic of Poland of last October, which refused to comply with the decision of the Court of Justice with regard to the rules on the appointment of judges to the Supreme Court. Polish resistance to European standards has also been extended to the level of the European Convention on Human Rights, which we have covered this morning, in particularly in the recent case of Zeroflor versus Poland. Focusing on the first judgment, on the judgment of the Polish Constitutional Tribunal with regard to supremacy of EU law, much has been said about the dangers and the implications of the ruling. The European Commission had an immediate and inflamed reaction to the ruling. Public opinion and some academia immediately discussed the possibility of Poland leaving the European Union. In my view, the judgment is less important for what it says than for what it actually discloses. And let me try to explain why. Constitutional Court's rulings refusing the full scope and consequences of supremacy of EU law are not new. They are not new to the Court of Justice of the European Union. They are not new to the Polish Constitutional Court. As has been previously mentioned as well, last year, in the peak of the first wave of the pandemic, the German Constitutional Court itself refused to comply with the decision of the Court of Justice on a very different subject that dealt with the validity of a European Central Bank decision on the validity of a program of purchase of assets of 2019. As it is well known, the German Constitutional Court, which happens with several constitutional courts throughout Europe, have maintained an intense dialogue with the Court of Justice with regard to the consequences of the principle of supremacy, and several times have threatened to overrule EU norms on constitutional grounds. And obviously, no one discussed the possibility of Germany leaving the European Union when that ruling was delivered, although it's true that it was very criticized not only by the European institutions, and in particular the European Commission, but also by academics in general, calling the attention to the precedent effect and to the danger and to the open door that the German Constitutional Court was leaving for other member states to resist and disobey other judgments of the Court of Justice, in particular those member states who are already struggling with the fight on the rule of law with the European Commission. In any case, these resistances to supremacy of EU law come from several constitutional courts throughout Europe. Actually, somehow the Portuguese Constitutional Court also adopted a similar approach very recently, last year as well, a fact that the Prime Minister of Poland emblematically highlighted in his speech before the European Parliament. The Polish Constitutional Court itself has, since the very beginning, resisted unconditional and absolute supremacy of EU law in its decisions on accession, in its decisions on European arrest warrant, and the Lisbon Treaty. So this is nothing actually new with regard to the relationship between constitutional courts and the Court of Justice of the European Union, in what supremacy or absolute supremacy of EU law over national constitutional guarantees is concerned. However, the problem is not the decision itself, it's the context that lies behind it. It is the first time the head of government of one of the member states challenges directly the validity of the treaties before a constitutional court. A court which is allegedly composed of sympathizers of the executive, and a court who, in radical terms, has decided on the unconstitutionality of key provisions of the treaty on the basis on the grounds they consider that they hinder or they compromise the sovereignty of Poland to decide on domestic judicial procedures. In reality, even if we can say that this is a classical supremacy case, it is actually not a classical supremacy case, because it goes beyond the dynamics of constitutional dialogues in Europe. The current state of affairs in Poland actually demonstrates that with regard to supremacy, not anything goes. The threats to the independence of the judiciary in Poland are well known. We have covered almost all of them yesterday, so I will be very brief with regard to recalling the jurisprudence and the case law of the Court of Justice, the recent case law of the Court of Justice in this respect. You have there just a mention to the most relevant cases. Poland was condemned twice for the rules on the retirement of magistrates. It was condemned in November 2019 for a regime that determined that the application of EU law would fall under the exclusive competence of non-independent and non-impartial bodies. In March of this year, the court held that successive amendments to the Polish law on the National Council of the Judiciary infringed EU law. On April 2021, also of this year, the Commission brought another action with regard to several amendments that have been introduced to several pieces of legislation in Poland dealing with courts and tribunals, an action that is actually still pending. And recently, July of this year, the disciplinary regimes for judges in Poland has been declared to be in breach of EU law. Poland is not alone in this fight, and we are also familiar with the example of Hungary, where the independence of the judiciary, a compliance with rule of law, has also been the object of several decisions of the Court of Justice, actually decisions that go back to 2012, with the idea that the radical lowering of the age of retirement of judges was unjustified discrimination founded on age. And more recently, this November, a few weeks ago, the Court of Justice declared that the Supreme Court cannot compromise or declare unlawful a preliminary reference made by an ordinary court to the Court of Justice in a proceeding where the national judge had actually been subject to disciplinary proceedings for putting a question to the Court of Justice. The case of Hungary, as Paul Rangel and José Manuel Pereza have also highlighted, is much more complex and has a lot of other dimensions than the Polish case. It has actually involved the breach of other rule of law principles dealing with funding of NGOs, the bill on universities, the systemic and continued refusal to apply EU law on asylum and migration. And as of November as well, the court again issued a decision on Hungary dealing with the criminalization of entities providing for international protection to migrants. So it's a much more wide-reaching case than, I would say, Poland at this moment. In any case, and because the title of today's panel is the future conduct or the future lines of conduct by the European institutions, I think the question now is actually to know what will follow from this. So what is still possible to do with regard to the crisis, what action can actually be pursued by the European institutions and the member states to control the flourishment of illiberal regimes in certain member states of the European Union. And the previous members of the panel have already highlighted the need to conclude Article 7 and the need to somehow consolidate the proceedings, the rule of law dialogue. I will try to point out some alternatives that are available. Some of them will seem less likely to produce relevant outcomes. Other ones can be further explored by the institutions and the member states. So I will start with the less likely to produce relevant outcomes, which is withdrawal from the European Union and all the discussions on Pole exit or the exit from the European Union of member states that are found to be in breach of the rule of law. It was actually suggested that by some scholars that the issuing of the decision by the Polish Constitutional Tribunal could be understood as a kind of notification or intention to leave the European Union. If any doubt arose from that, the Prime Minister of Poland left very clear in the European Parliament that there is no intention at the moment on the side of Poland to actually leave the EU. They are here to stay. Being, for us, European integration is a civilizational strategic choice. We are here, we belong here, we are not going anywhere. So I would say that withdrawal of Poland or any other member state at this moment is clearly off the table. There are some hopes with regard to the future of the rule of law framework that would somehow succeed to the rule of law report that has been carried on by the Commission so far. There's actually a proposal by the European Parliament to create a new mechanism on democracy, rule of law, fundamental rights. It has been also referred previously to avoid that would somehow avoid duplication of procedures and would allow for more oriented and targeted recommendations to the member states, and that could be definitely the way forward. I have some doubts on the effectiveness of this mechanism, to be entirely honest. I think the Commission has contributed with its own action to weaken the full scope and the full force of this mechanism. It has only activated the rule of law dialogue with regard to Poland. It has failed to act against other member states regarding which it expressed some doubts and some preoccupations. So we will see in the future if the new mechanism will produce more relevant outcomes. I also agree with what has been said before on Article 7 and the need to conclude Article 7, Paragraph 1 procedure. It would be the first time that the Council deciding by a fourth-fifth majority would assert that the rule of law is under threat in the European Union. That would definitely put some political pressure on the states and combined with other courses of action that would contribute decisively to the resolution of the crisis. I think there's something also to be done at the level of actions for infringement, and in particularly by the Commission. The bringing of new actions for infringement has also been mentioned before in this conference. At the outset, the Commission could react to the decision of the Polish Constitutional Court of October of this year. It is clear since Commission versus France that the European Commission is willing to bring such an action when the failure is imputable to the judiciary. It has done so with regard to Germany in the Weiss case. And it's clear that the Commission could initiate further action at this level. And some candidates have already been put forward, like actions tackling directly the composition of the Constitutional Court in Poland, the competencies of the Extraordinary Chamber of the Supreme Court, the composition of the National Council for the Judiciary. And additionally, it's important not to forget that the Commission maintains the possibility of asking the Court of Justice for the enforcement of its own judgments through the imposition of a lump sum or a penalty payment. The enforcement infringement action that is foreseen also in the treaties that could somehow put more financial pressure for the member states to comply with the court's judgments. Also, it has been argued that the actions for infringement could somehow be rethought and reframed in such a way that they are brought and that they are devised as covering not only individual laws or individual measures, but they could be brought on much broader terms, an action for a systemic violation of the principles of the rule of law. This would allow for a more wide-reaching judgment of the Court of Justice, probably a more effective judgment by the Court of Justice, and would allow to tackle systemic problems and not isolated measures one by one. And lastly, at this level as well, I would say that as the time is of the essence in this battle, the Commission could consider reducing deadlines for action, could open proceedings immediately after laws are adopted. It hasn't happened so far, so the Commission takes quite a long time to bring infringement proceedings. It could reduce the time for the reasoned opinion. It could refer to the Court of Justice immediately once the member state does not comply with the opinion that is issued in the first stage of the procedures. The Commission should continue to ask for interim measures to the Court of Justice, and the Court itself can decide to apply the accelerated procedure if it considers that the case should be dealt in a very short period of time. Hopes are currently being focused on the conditionality regulation. A lot of things have been said before on the avenues that this budgetary conditionality actually opens. The fact that it's currently subject to a moratorium or a de facto moratorium doesn't help. Of course, Hungary and Poland will do whatever they find possible to challenge the validity of these measures, and the fact that the political institutions have somehow conceded and have somehow agreed that the regime will not be applicable until the Court of Justice delivers the judgment. They somehow have delayed the effectiveness of this solution. This is definitely politics and not just juridical processes. And last but not least, and I would end with that reference, the importance of the political process. Courts can only do what they are meant to be, to do. And in Poland and in Hungary and states where the threats to the rule of law are happening at the moment, they will be able to do less and less. So it's very important that we settle for the idea that this crisis has to be politically contained somehow. And at this level, there is much to be done, I would say. Council should definitely resume and conclude Article 7. Member states should be more clear in supporting the actions of the Council. The European Parliament could organize systematically debates on the rule of law reports of those member states that are found to be in breach of the rule of law, the most problematic cases at least, and the Commission could do more to explain its work, its intentions, its course of action, but also its constraints and its limitations. Truth be said, in the end, the resolution of the crisis will pretty much depend on the goodwill and the cooperation of the institutions and the member states. In the European Union, it's not possible to resort to the use of force, as we know, as happened, for instance, in the United States, with the enforcement of the famous decision by the US Supreme Court, Brown versus Board of Education. Those events cannot be replicated at the level of the European Union. We do not have the force and the means to enforce judgments in such a way. So the role of politics is definitely imperative. At that level, I would say that notwithstanding the need to find an immediate response to the crisis and what's happening at the moment, it is important that we find political solutions that ensure the integrity of the Union in the future and that ensure that the Union remains a union of law. I think that these cases, it's not worth to discuss these cases in light of the idea that EU law trumps national law or national constitutional law. I think the cases are not about supremacy of EU law. They are truly about primacy of union law, which means that they go much deeper. They go to the very foundations, to the very vocation of the European communities. When I was hearing about the story of the Turkish judge that fled Turkey, that is now asking for asylum in Europe, or the stories of those brave Polish judges that still refer questions to the Court of Justice and that insist on applying EU law in the cases they are called to decide, I remembered Hannah Arendt's words when she referred to those rare moments when chips are down. And it is crucial that we maintain the capacity to distinguish right from wrong. And I believe we are going through one of those moments. And as always, it takes courage to fight it. Thank you for your attention.